Sorry. Yeah. 1 second. All right. So there are three steps to solving a legal reasoning question. The first step is making a test from the principle. Second, applying the, the test to the facts. And third, eliminating options and identifying the correct one. So let's start here at step one. Okay, so for step one, each principle in a good CLAT paper will give you the law in itself. You do not need more information to solve that question. That is, if it's a good CLAT paper. For the bad CLAT papers, we'll come to it at the end of this video and we'll talk about how your knowledge of law is helpful. But let us stick to a good CLAT question paper right now. So a good CLAT question paper will give you all the legal knowledge required in the principle. So your role is to identify and extract that knowledge and make it a test. And once you make it a test, you apply that test to the facts. And then you filter it out to relevant facts, and irrelevant facts. So once you filter out the irrelevant facts and you can identify the relevant facts, you apply the test. So in most cases you will come up with an answer. You will, by after step 2, you will come up with an answer. But still it's best to always go for eliminating the options, just as a safeguard to ensure that there's no better option than the one you have come up with. So, and then finally you can pick up the one most appropriate answer, which is the correct one. And following this simple algorithm, I can assure you that your accuracy in the legal reasoning portion is going to increase by a lot. So let us try applying this to uh, a question from CLAT 2013. All right, so let us try applying it there. So let's solve this question 151. So the principle is, when an offer is accepted by a person to whom it is made, it becomes a promise. But this promise will become legally binding only when the acceptance of the offer is unconditional. Okay. So for a promise, so we saw the principle, right? So question 151. So you've seen the principle. So the principle talks about when is a promise legally binding. So for a promise, for a legally binding, you need two things, right? You need an offer and you need an unconditional acceptance. So this right here is your test, right? So this is your test. So now you can filter out any of the unnecessary portions, right? So let us look at the facts. Fact says Ram makes an offer to sell his house to Sham for 50 lakhs. So the offer portion is satisfied, right? So there is an offer. Sham accepts this offer but wants to pay the price in 5 quarterly installments. Ram does not agree to it. Thereafter, Sham agrees to pay the price of the house in the way as it was originally desired by Ram. But Ram does not reply to it. Can Sham compel Ram to sell his house? Right. So let us look at the facts here, right? So there is an offer and there is an acceptance, right? So the only portion you have to consider ourselves is whether the acceptance is conditional or unconditional, right? So in from the facts, the only portions which are relevant is this, right? It's this, that whether imposing another condition of 5 quarterly installment still counts as unconditional acceptance, right? So Ram does not agree to it and thereafter Sham agrees and all. It's not very relevant because for us, once the offer, only when the offer is unconditionally accepted does it become legally binding, right? So what if the offer is not unconditionally accepted? What happens later we don't know, and we don't really care what happens later, right? So let us see whether five installments so whether five installments so whether five installments still makes it unconditional. So let us assume that yes, let us assume it's unconditional. Now let's look at the options. All right. So option A is Sham can compel Ram to sell his house because Sham ultimately agrees to pay the price as originally desired by Ram. All right. So you see, this principle does not talk about what happens once you give an conditional acceptance, but you later make it unconditional. So it's very unlikely that this is the answer, because that so because Sham later agrees does not mean that this acceptance become unconditional acceptance, right? So if I ask you, do you want an ice cream, and you say maybe in 10 minutes. So after 10 minutes, you cannot force me to give you ice cream, right? I mean, it's not a good example, but you get the idea, right? So you go to an ice cream shop, the ice cream guy offers to sell you an ice cream for 10 rupees. You say, no, I'll pay you 5 now, pay you 5 later. He refuses. Then later you say, okay, and then he leaves. So can you go to court and say, oh, he didn't sell me that ice cream in 10 rupees when I was ready? I mean, the conditions have changed. That principle is not there. So that portion is irrelevant. Yeah, went on a tangent, but you get the idea. So let's go to, so wait, option A, it's very unlikely. I don't want to cancel it because some of the bad NLUs, they frame paper these ways, and then you need to use your prior knowledge and all and then get answer. But let's just label it unlikely. Then there's option B. Sham can compel Ram to sell his house because Sham in the first instance substantially complied with the desire of Ram. Okay, so nowhere in the principle do we see the concept of substantially compiled with the desire. No, I mean, this is going into the definition of what is conditional or unconditional acceptance, right? So if we choose this option, we are saying that if you substantially comply, it becomes unconditional acceptance. But this is not there in the principle, right? So it's best to leave this option as also unlikely, right? Let's say option C. Yeah, so Ram cannot compel because Ram's offer does not exclude the price of payment and installments. Okay, this is again not there in the principle that the person making the offer has to exclude it, but it's a likely cause of confusion. For scenarios like this, I mean, the way I do it is just what what other things has he not excluded? He has not excluded saying giving the house on interest-free loan, right? Saying, oh, you can make the payment 10 years later. He's not excluded that either. So the thing is that, so when you're making an offer to sell a house, unless it is specified that you can use this payment or you can pay later, you it is assumed by the law, by default you have to pay immediately, right? So that is like basic law. If you go to the shop and the shopkeeper says you can buy a packet of chips for $10, that does not mean you can pay him 10 days later. It means you pay those $10 now and then you can take the chips. You get the idea, right? So the default, by default, the thing is that you have to pay immediately. So unless something else is specified, the default rule applies. So it does not have to exclude the payment of prices. So this answer is just a no, right? So option cannot because imposes a new condition upon payment of price and while accept while accepting the offer which is not ultimately accepted by them. So I mean, just by elimination you can see D is the right option. But even now if you see, so 5, like I told you, with this option which made it clearer, so 5 installments is a new condition that Sham is imposing on Ram. Do you get it? It's a new condition. It is a condition. You may think it's not a big deal, but that's not relevant because you're not the judge. You just have to follow the question. The question says condition, right? What if Sham had said, oh, I'll buy the house for the same price, but I want it painted blue? Is that a condition? Yes, that is the condition, right? You understand that is a condition. So this acceptance is conditional. So the correct answer is D. And this is just an example. You might think it's complicated because I'm introducing a lot of, say, big terms and going around about it in a convoluted way. So let's just check another example. Yeah, let's just check this, right? So question 163. So in this question, an agreement may be written or oral. However, if the law specifically requires that an agreement must be in writing, then the agreement must be in writing. If the law specifically requires, a law specifically requires that the agreements related to transfer of copyright in a novel between an author of a novel and the producer of a motion picture must be in writing. All right. So, question 163. So, transfer of copyright in novel must be in writing, right? Why? Because it's specified by law. So this is your test, right? This is your test, that if it's a transfer of copyright material, then it must be in writing. Otherwise, it's not an agreement, right? This is an agreement, has to be in writing. Actually, it depends on the law, but let us just assume that it has to be in writing for this minute. I think that's sufficient. All right, so let's look at the fact. The author of a novel has had several rounds of discussion with the producer of a motion picture regarding making of a motion picture based on love at Lost Sight. During the last discussion, they decided to make a motion picture on Love at Lost Sight. The producer made a motion picture on Love at Lost Sight after making a payment of rupees 10 lakh in cash to the author, who happily accepted the amount as full and final payment. Alright. Later on, they brought a case against, saying there's no written agreement between the producer and him. Alright, so let's look at the facts, right? So this portion, it's a discussion. So basically here he's selling his novel to a producer, right? So what you have to see is that nowhere in this fact does it mention that there was a written agreement, right? Nowhere in this fact. Okay, copyright in a novel, I hope this much basic law you guys know to understand that basically means whatever authorship rights you have over the novel. All right. So in the facts, you see all these facts are irrelevant. All these facts are irrelevant. I mean, all these facts are irrelevant. Why? Because our principle only concerns itself with whether it is in writing or not, right? So nowhere is it mentioned that it is in writing, right? So after applying the test to the facts, what we get is that yeah, the author can go to the court, right? So then option one is, so yeah, let's look at the options. So option one is author is likely to succeed in an agreement in the case that the agreement is not in accordance to law. That is correct because the agreement is not in writing, so it's not in accordance to law. Author cannot succeed in the case as given consent to the agreement. Again, I'm just the agreement has to be in writing, right? So there is how I mean the because he gave consent does not mean he can change the law, right? If you and I decide that stealing from someone is not a crime, it does not, I mean, we'll still be liable for theft. So two people cannot decide and change the law. A person cannot by his consent change the law. But this option is just, you just have to ignore this option. I mean, just this is wrong. Then it's not likely because he's already accepted 10 lakh rupees. Okay, you are not a judge. All right, you are not a judge. You don't have to. I know it feels really bad about this 10 lakh rupees. He took the money, but he's now going to court. He's not a nice guy, maybe. But that's irrelevant because nowhere in the principle does it talk about money or if he had taken money or if he had given consent. All those things aren't mentioned. All that it says, it has to be in writing. If it's not in writing, it's not considered an agreement, right? Again, the consideration is inadequate. That is also not given in the principle. So you need only concern yourself with this portion given in the principle, right? All these things may play a role in real life, but then that's up to the judge, right? I mean, you are not there to think how to apply each fact and give a decision based on this much fact. So don't try to pronounce a judgment on the question. Just look at the principle, apply it to the facts, and write the answers, even if it is leading to injustice. You don't care about justice at this point. You just care about getting the right answer, right? So okay, so for this 163, the answer is A. I'm sure that's the correct answer. I can scroll down and check. 163. The 151 we did D, which was, yes, it says the same thing. 163. Since the law specifically provides for an agreement related to transfer of has to be in writing, the author will succeed. So the answer is A. So you got that. So similarly, you can solve, basically you can solve any question on legal reasoning just applying these steps, right? So don't get disheartened. I mean, obviously there'll be confusion between two options, sometimes even three options at the beginning, but as you get used to applying these steps, you will be able to filter out all the irrelevant details, which basically come about because you try to act as a judge mostly. You shouldn't act as a judge. You should just apply the facts to the, I mean, apply the principle to the facts and then come up to the answer. All right, so yeah, I think I'll make another video about what to do when the questions aren't good in themselves. So in those cases, you do have to study, but that also not a lot. Just a basic idea of the law will be enough. But yeah, that I'll do in the next video. So yeah, thanks.